I think we're ready to get started in our new venue. This is a temporary change of venue. We will be going back to 1000 Washington Street. I am pleased to call to order public meeting number 29 of the Massachusetts Gaming Commission, September 25th, 2012. We'll start out with the approval of minutes, and there are two sets. First, September 11th. Commissioner McHugh.
These this morning, so I don't know whether everybody's had an opportunity to read them, but if they have, I would move their approval. If not, we can approve them at our next meeting, which won't be for 2 weeks, but we can post them as drafts in the interim on the website to give you a chance to read them if you prefer to do that. So
I
can
read
do it
them,
either way.
so you guys, is everybody ready to go ahead?
I read them. I have a quick change on, under research agenda on page 404 and 5. The gentleman's last name is Robinson, not Robertson.
Oh.
Okay, thank you.
And I had one on page 2. The bottom of the third paragraph. The firm stated, however, that it did not represent any gaming company with Massachusetts interests and would not do so. I don't think that sentence is really what we meant to be saying, because they do represent companies with Massachusetts interests. But they don't, I assume what it meant is they're not being represented in the Massachusetts situation.
All right.
I think it's just a
All right. I see the point.
okay. Any other? Do we have a second for the motion?
I second the motion.
All in favor? Aye. Aye. That one adoption. The ayes have it. And then September 18th. Commissioner, I just had a couple typos here.
Okay.
Anything on September 18th? Is there a motion, Commissioner McHugh?
Yes, I move the acceptance of the September 18 draft minutes that were distributed.
Second.
Second.
All in favor? Aye.
Aye.
Opposed? Ayes have it. Okay, then we get to the business, the big business of the day, project work plan. And although under consultant status report, their little I-2 says is draft master schedule, I thought we'd start with the schedule. So if you would introduce yourself. Does everybody have a copy of the chart? Does the audience have a copy of the chart? Okay. Eric, why don't you introduce yourself and then explain to us what we are looking at here.
Good afternoon. My name is Eric Lothar. I'm with PMA Consultants and helping the commission with schedule and the work plan. The last time I presented at the public meeting, it was in July 10th meeting, and I discussed the proposed approach to how we would integrate the various consultants and the commission's work plans into one integrated master schedule. And I'm happy to report that we've made great progress on that since our July meeting, and we now have an integrated schedule that reflects the scope of the gaming consultants and the commission's work. And the handout today represents that workflow, and just briefly discuss that. On the top of the schedule is a gray band, and that's the summary representation of the plan. And each of those individual tasks is a roll-up of several activities, 10 to 15 activities that represent that specific workflow and the sequence of events that have to happen to achieve that particular item. And as you can see, that these series of tasks, some of them already ongoing, translate to our milestone for the Commission's award of the first license. And that date, as everyone can read, is the end of February of 2014. Probably interesting to understand which series of tasks actually control that forecasted date. And so below the gray area is in more detail the representation of the specific tasks that represent our schedule, and the ones that are in color, not grayed out, are the controlling tasks that represent the longest path to the first issuance of license. And it really begins with the work that's already been achieved with Phase 1 regulations, which flows into the RFA Phase 1 applications. That process as well is ongoing, and It leads into a major task of scope of licensings for investigations, and then the prepare and submission of applications. That then steps into the background investigations and suitability of applications process for phase one. It's a 6-month task. Leads into the MGC review and a hearing period, which then flows through to local negotiations and vote for surrounding community agreements and host community agreement approved by referendum. That leads into the last activity, which is the commission's review of responses for RFA 2, and ultimately the license issuance.
Let me just give you a couple. This is great, and you've all heard us say that we've wanted to have a really comprehensive project management chart that had critical path items on it, so we could track our own work, so we could communicate better with the public about what's going on, and so that we could isolate where the time sinks are and do everything in our power to shorten those. This particular plan has the first license award in February to March of 2014. That is what our consultants would call, I think, a prudent, based on prior experiences, schedule. You have heard us say, and we have posted, that we could possibly, if things went really well, get it done in 2 or 3 months before that, possibly in October and November if things really went like clockwork, possibly the slots casino, which is a little bit less, a slots parlor, a little bit less complicated. But that's the range. When we publish these charts, we will frequently target the next fall, because we all believe if we have a target, we will try like hell to make the target, but the plausibility is that it'll be somewhere between October, November to February, March. That's the realistic time frame. Now, if you go through these, the dark green down below is the longest line on here, and that is the one for the background checks. And as we're going to now jump into conversation about this, because we have a project management group who knows how to build these things, but our consultants have done the strategic plan, and they've come up with all the data that populates this chart. PMA just gives us a tool that we can use, and gives us these tools to see where the interplay of the critical path items are. But I think I know the commissioners have a lot of questions about timeline that have come out of the draft strategic plan. But I just thought it was interesting for people to be able to see that long period of time. We're in the prudent schedule. We're allowing about 6 months for background checks. Some probably will be sooner, some probably will be longer, but our consultants tell us that we can prudently plan to have the background checks pretty well done in a 6-month period. We will try to compress that, which is one of the major ways we might be able to get back into the end of 2013 for our licenses. So, commissioners, do you want to draw either to Eric about the tool itself, or are we ready for our consultants to come up? I think we're ready maybe to skip into the strategic plan conversation. But go ahead.
I will just mention one small thing that I know there's additional activities in this master schedule that are not represented for convenience.
There's many other lines underneath this that we aren't showing, but when we get it done, everybody will see all of it.
Right.
Thank you.
But there's importantly another what has been shaded or faded out a little bit is very critical activities that will be ongoing at the same time that those investigations will take place for the commission, and those are represented at the bottom, which has to do essentially with all of the drafting of the phase 2 regulations. Right. And so these major tasks will be running in parallel. As Eric and the chairman were describing, the longest one, thus the critical path, has to do with investigations. But there's others that are important that have to do with regulations.
And you can also see here the conversation that we had with Springfield, which on this chart represents the way the process should work, and it now will work, I think, right. Which is that the host community agreements will not be submitted to, and surrounding community agreements, host community agreements will not be submitted for a referendum until after the background check, the green line is completed, whether that's Springfield or anywhere else.
Well, but until after all background checks are completed, or until the background checks involving the applicant is completed?
The background checks involving the applicant are proceeding,
Right,
right? So
right.
it can happen
So it could
seriatim.
happen sooner, so that, just so that those interpreting this, the surrounding community agreements under this schedule are not put to a vote until the end of September of 2013. But if a particular applicant's background investigation is done earlier, then that
Absolutely,
can be opened up, and that can happen a lot earlier.
which is very much what Springfield is hoping, for
Right,
example, to do.
right, right.
That's exactly right. And, you
Right.
know, all of this is built in sort of average parameters. If you see the beginning of the dark green line is January, when the background checks begin. If we get the RFA1 forms in sooner, and we probably will get some in sooner, maybe as early as the end of October, mid-November, we can start then. So that will automatically move the lines around. But this is a sort of a macro assumption for everybody. But that's a very good point, Commissioner. And, you know, any community and developer that are working together that want to expedite the process, starting sooner, giving us the tools to start sooner, making sure that the first step in the RFA1 process, after you get the forms themselves, will be a conversation with the commission about who need to be pre-qualified. Who are the qualifiers that we will need to submit to the background check? Corporate, institutional, and personal. And there frequently is some debate about which parties need to be background checked. We will ultimately decide, but we talk about it with the bidders. If that argument doesn't go on for a very long time, that can save time. If the forms are filled out quickly, that can save time. If the forms are filled out accurately, that can save time, et cetera. And then we will move heaven and earth once we get everything to get our part of the job done as quickly as we can. And our consultants have sort of resisted us trying to squeeze the schedule down because they're trying to get us to be realistic and set expectations appropriately. And we're walking that line between, on the one hand, trying to be as ambitious and aggressive as we possibly can, but realistic on the other.
And on that note, Mr. Chair, I would highlight also that as an interactive planning tool that this is, as we learn additional intelligence relative to what you just mentioned, whether those investigations are taking less than anticipated, this tool will allow us to reflect that. And the schedule, as was demonstrated when Eric was first with us, would adjust very well.
And some of the things that aren't on here, for example, is the hire of our key employees. They'll be plotted out. The detail on research projects. There's a lot of other steps that we actually have in draft form, but we just didn't show today. Okay, do you want to?
I had
Submit,
I
yes.
had just one question, because we can only do this in this kind of a public meeting, and so I had just one technical question about the chart itself, and that is, there are a number of activities shown at the top, and we don't have all the detail below. But do we have some mechanism for assessing resources that we need in order to maintain those timelines, the interconnection between resources available to do one task and another? How are we handling that? Maybe we're not, but
So
at the moment.
currently, the activities aren't resource loaded, but they could be, absolutely. And that'd be just an exercise of sitting with each task person who's responsible for a given activity and understanding the resources that will be required to complete the task in the time allowed, and then incorporating that into the schedule.
I recognize that gets us into the kind of planning that goes into building a building, for example, and it's an imprecise art, but the experience of the last couple of months leads me to believe that some effort at doing that would be worthwhile, even if it isn't done with all the precision that we would do to fully resource load schedule of this type, because as I look at this is very ambitious. I know we're going to be hiring additional people. We're well on the way, but I would prefer to do that earlier rather than bump into something later and see that we just can't do it, or we're going to do it in a half-baked fashion because we don't have the resources to do it.
Maybe Director Glovsky, where's, yeah, if you could make a note about that and with Commissioner Zuniga and Eric and see whether we can, what that would require, what that would look like. Okay, thank you very much.
Thank you.
It's a great tool, and we're getting very close. It's exciting. Any 6,000 consultants want to come forward? Eileen, that chart you did of issues, of key topics, did you bring that? That little email you had? I forgot it. Okay, let me, to the extent, any of the issues that you all raised, if there are issues about the timeline that we wanted to talk about, that's a good place to start. But I just want to sort of try to make sure we're all on the same page, and maybe anybody disagrees on this. The primary work product beyond the regulations for RFA 1 from our team of consultants has been the strategic plan. That was the main thing that we originally procured. The strategic plan is now a work in progress and is in draft form. The primary purpose of today's conversation is to feed back to the consultants items that they will need to do a final draft or at least another draft of the plan. Not necessarily to answer all the questions that are raised in the plan. The plan's purpose, one of the plan's purpose, is to raise the issues, the policy decisions that we will have to make and show us where on the critical path those take a place. So there's a tendency now to get into a conversation, and for example, the strategic plan talks about different ways you can organize the legal department under the general counsel. Well, that's not what we're here to talk about. You know, there'll be a time and a place for that. If we felt that there shouldn't be a general counsel or there was some whole piece missing, then that is what we're here to talk about. Now, if there are issues which are really imminent and we need the consultant's advice on them, then that's certainly fair game. But I found myself wanting to start talking about issues that you're not trying to raise for discussion right now. You're just trying to tell us that in due course they will need to be addressed. So I think that's an important distinction, may help us save some time. So, having said that, who would like to start off on questions and comments about timeline for starters, and then whatever else you got?
Well, I can do that. There's two critical pieces that I see happening in the very near future, and that have to do with timeline, but it really starts to beg the question for us, for the Commission, with the input of our consultants as to how we organize ourselves and set ourselves up to do that. And the next one is the closest, which I know we may discuss these later, or we may discuss that now, but has to do with the start of drafting regulations of for phase 2. And which has been identified here as starting essentially in November. To review the scope and start drafting those regulations. I'm setting that as a general comment. That's one of the next steps that we need to consider, and any feedback and comments to that effect, I think, would be worthy of discussion.
Well, I have two that jump immediately to mind, and they sort of pull in different directions. I wondered, first of all, looking at the timeline, the chart that was prepared and that we've been looking for, and the first page of that, whether or not it would not be possible if one looks at item 8 on that chart. I don't know whether everybody has it, but
You're not talking about this chart. You're talking
no,
about
I'm talking about the
okay.
timeline chart. But basically, it's this. The commission conducts hearings and determines suitability. That has to come at the end. Well, it has to come after there's something to conduct a hearing about. And so there has to be an investigation before you can conduct a hearing. I mean, that's logical. But I wonder if we were to get a good cooperation from the applicants and get the material that we need to satisfy ourselves that the investigation's been, that we have the material that we need to make a judgment. If we couldn't start those hearings actually almost a quarter earlier, that would be 5 months after the RFA1 was issued. And if we could start those and move that whole segment back a quarter, we would change the sort of realistic deadline back to sometime in late 2013, i.e. a deadline, the target date for issuing the first license. I just wonder how realistic it is to think that we could get at least some of the information we needed in order to have a hearing and make the suitability determination a quarter earlier.
I guess I'd have two responses to that. One, if you're saying that a suitability determination can be made on the basis of some of the information, I don't think you're saying that.
No.
So you need, obviously, as you say, to complete the investigation to the satisfaction of the commission that enough information is there to make an informed judgment. The time that will take to get to that point is extremely variable. And as has been pointed out earlier today, it's the cooperation of the applicant, it's the number of issues that might be raised, it's the previous history of the applicant in terms of its regulatory experience, and so on. So it's entirely feasible that an investigation could be completed in a shorter period of time. It would all be a fact-based and case-by-case analysis. So the times that we have suggested here are reasonable estimates, balancing, as the chairman said earlier, the public policy to get these things going as quickly as possible against the need to make sure that everything is done right. If there is a possibility to do it faster, there certainly is no objection on our part to doing that.
Right.
And let me just clarify, there are a number of other areas where the timeline might be accelerated. As you alluded to, the issues on scope of licensing are booked for a certain amount of time here,
Right.
but they may be less than the time specified in the chart. The filings could be made quicker and the investigation. So, while this has certain benchmarks here, it's reasonable that they may be able to be compacted and the process can be accelerated. Our recommendations are based on just what we have seen in other jurisdictions, but we learn from other jurisdictions and the work we've all done collectively in other jurisdictions, how to try and accelerate the process. It's a process that is controlled by the commission in a large measure, but it's also dependent upon a lot of variable factors, as Guy has mentioned.
It seems to me that that's an important point for us to stress publicly as we move down the road, that we can move faster if we get cooperation from the applicants, both with respect to the initial filings and with respect to the information that we look for as a supplement. And we can only take the speed-up process, which everybody is interested in, consistent with due diligence so far without that kind of cooperation. So the second point is unrelated, and it actually pulls in maybe in a different direction. And I just noticed it when I looked at this chart that we looked at today, and we've set aside basically on the planning chart about until June of 2013 for the Phase 2 regulations. And I know we've been talking about that collectively, and that seems to all of us to be a realistic date. But in order to get them out by June of 2015, we've got, 2000, I keep pushing it back a year. No, I pushed it back 2 years.
Not that long.
It's,
That's conservative.
2000, that's not a Freudian slip. But 2013, we've got to be prepared to give notice to the Local Government Advisory Committee, which means presenting them with a full set of regulations by mid-March of 2013. And I think that's something worth noting. That's not very far away.
You got that on?
There also, and we have discussed this in the past, the possibility to prioritize those regulations into certain categories, so
Right.
that those that are necessary at the beginning can be accomplished timely. Those that aren't necessary can be delayed until they become something that's needed.
Right. So that emphasizes the need to think about that.
That, I agree with that, and I hadn't noticed that on the timeline, but I think that is something that you could do in the next draft, is to begin to make that distinction, because I think we all agree now, we've talked about this a little bit, a couple of times, that for the time-sensitive issues, it's just the matter of which regulations do we need to make the licensing decisions. Right. All the ongoing operations and regulations of the facilities themselves, we've got plenty of time for that. Right. So I think that's a really important point, to front load, and I think that's something your strategic plan coupled with you could help us really understand exactly what does that mean, and exactly which ones are we going to be working on during this initial period of time.
May I actually pick up on a point that you made at the previous meeting, Commissioner McHugh, which is that as early as we can, draft those regulations and communicate to our potential applicants or applicants what and how this commission is going to be evaluating those proposals. Not represented here in this sheet is all the time that those applicants need to develop and fine-tune and those such proposals, which is critical in this time frame, because they want to be as thoughtful as they can.
Right. Yeah, this, as you say, Commissioner McHugh brought this up before, and that's on my list of things, but I think you could help us think about what are the policy decisions that we need to forecast to the municipalities and the developers, so they know, even before we've set the regs and everything else, we can issue policy advisories. And I think we can do some of that ourselves, but I think you could help us a lot. So those are two sets of revisions that would be really helpful. Who else?
Well, just wanted to pick up a little bit on the notion of, or that critical path of the background investigations, which Guy and Fred, you alluded to. They highly depend on the sort of cooperation and questions that may come from potential applicants. So to that end, and to a previous question relative to resource loading this schedule, how would you, and perhaps you already answered this question, but how would you characterize our ability to either shrink those 6 months, or whether those 6 months are realistic or aggressive in order to meet that schedule? Whether we doubled up or tripled up on investigation resources, let's say.
Well, I think the first thing I want to say is in most states, Nevada, New Jersey, the major gaming states, and we look at Massachusetts as a major gaming state attracting major applicants, the timeline for an investigation is anywhere from minimum 9 months to 18 months. Now, in some of the states, there's opportunities for temporary licensure while the investigations proceed, interim casino authorization or whatever. Unfortunately, that's not part of this law. So we have to deal with the situation we have here. Personally, and speaking for Spectrum, and I think Guy will speak for his company, where we think it's not a matter of investigative resources. It's because the number of applicants are somewhat predictable. It's just compacting the process, and 6 months is what we think is a reasonable time period. And again, to the extent that we can reduce that period of time, it's in everybody's interest. Everybody wants to get the first casinos licensed and balanced with the critical integrity functions that are in the act and that permeate the act, to do it in a way. And I think it's worth repeating. It's just not, we're not just talking about Caesars, we're talking about their partners who are the applicant, some of whom may never have been licensed before. If it was just Caesars who had been licensed in multiple jurisdictions, I could stand before you or sit before you and say we could compact it, but that's not necessarily the case. So we have to be cautious, but we want to be aggressive and get through the investigative process so that ultimately the investigative process provides the commission with information so you can make an informed decision on suitability.
Yeah, I agree with all of that. In terms of resources, I just add a subtle point that presently, obviously, the commission does not have its own internal resources, understandably, to be able to conduct these investigations, so that the time schedule that we have contemplated would similarly contemplate that there would be a third-party contracted to conduct these investigations at the same time that the commission staffs up so that it can conduct them internally later on. The staffing, too, would have to take into consideration that you will ultimately not have these kinds of casino license investigations in the future. People will be licensed, and they'll be licensed for years, so that the other forms of investigation will be necessary, and the staffing will take on a different coloration at that point. So our view of this, which has led to the timelines that we've suggested, is presently a third-party contractor, ultimately to blend in with the internal resources.
Just quickly, it also seems that key to constricting the time frame is when you begin. I mean, you've made that point also. The sooner you can get started, the more likely you are to get a process going that might be able to be condensed. But the issue of condensing the time frame doesn't even begin to come into the discussion until
Right.
you can start
So we
something.
have
So the sooner you can start something, the more you may be able to visualize whether or not you can condense it. You have to know
Right.
what you're dealing with.
Right. That raises a question in my mind. You've frequently cautioned us that the negotiations over what is a qualifier, who is a qualifier, is often where the hang-up comes. If there's an organization applies, and we have a meeting on scope of licensing, and there's a debate, a disagreement of about a couple of players, can you get started on everybody else? So you're really, debating the qualifiers doesn't necessarily slow down the whole thing, it's just whoever just slows down the qualifier.
At the start of the investigation, there should be substantial agreement. In other words, if major companies or entities that comprise the entity have to be resolved, that's one thing. But if it's just a couple qualifiers and the application is materially
Right.
complete, then the investigation should and can proceed.
Typically, those disputes involve financial sources.
Right.
The structure of the company, their officers, directors are fairly clear. What's unclear are the relationships they have with different investors, different financial institutions, and those are the ones where the issues arise. There's nothing preventing the commission from focusing on those that are undisputed and then delaying the others.
At the risk of asking a really naive question, why does it take long to resolve those disputes? Why can't one simply say, looking at it from the commission standpoint, we understand your concerns and they're valid, so this person doesn't have to qualify, or we understand your concerns and notwithstanding your concerns, they're a qualifier. If you want to pursue it, you have to give us the information.
Well, in theory, I think that we agree with that. It's just that the applicants or sometimes parties who may not be the applicant but
Right.
control the applicant want to be heard. They want to file briefs. They want to address the commission. They want to make their argument before the commission. And we've been through this process in other
Oh, I know you have,
jurisdictions, and
yeah.
sometimes it goes smoothly, and other times it does not. And it's a component of the specifics of your law, not the law of other states, which sometimes, some companies want to apply, and the reasonableness of the approach and the willingness of the commission to make an accelerated decision.
Yeah, that's, the last part is what interests me, is the commission's approach to the decision-making process part of the formula for determining how fast this is going to go?
It can be, but again, not to sugarcoat this.
Right.
It's not a comfortable process to go through these background investigations. They're very thorough, and they can be considered by some invasive. And if there are investors who are invested in 600 other companies, and this happens to just be one of them, they resist, and understandably so, having to undergo that uncomfortable process if they can avoid it. And so they try to avoid it.
And it goes to the confidentiality issue as
No,
well.
no,
These
I-
companies are some of these companies are, to the extreme, sensitive to that issue.
Right.
And some companies may choose to withdraw. I mean, there's some aspects, some qualifiers may decide they don't want to get involved, or the company may not want them involved in order to delay the application moving forward. To make that decision whether to stay or to leave sometimes takes time, in terms of the company restructurings and so forth.
Yeah.
Well, that
To
has
some financial sources, this is 1% of their portfolio. It's a major portion of the financing, but if the institution decides it's not important enough to me to go through this, that can really prejudice the project.
Well, and I mean, that has happened on a number of occasions where institutional investors or companies who have exceeded the thresholds of institutional investors have switched to companies who would be more willing to file.
So that ultimately, again, to sort of pursue my naivete, that consideration is ultimately one for the commission to take into account in deciding how much it wants the information at what cost.
That's correct.
Yeah.
Some of it is not optional. To a certain degree, if your statute says they have to give you
Right.
whatever, at certain points, you don't
Right.
have discretion.
Right.
You're saying to them, statute says you have to provide X.
Right.
And the company goes, they don't want to have
Right.
to do that. It's not like you can say, well, okay, don't give it to us. Sometimes you've got statutory requirements that say you have to get it.
Right.
And the amount of discretion you have then comes into question.
Right.
Along those same lines, I think I have a good understanding of background investigations and what can slow the process, but specific to gaming, can you give just a couple of other examples of something that may slow down the process,
The investigation process?
the investigation,
Well,
background?
the issues that may surface in a particular company, you're dealing with some of your applicants or the ones that have been, surfaced to date are publicly traded companies that are large bureaucracies, and I don't characterize this as a failure to cooperate. It just takes time to produce information. As part of their bureaucracy can match any state bureaucracy any time from what we've seen over the years. Let there be no mistake about it. Then there are substantive issues that may surface that need more in-depth investigation. There's, contact with other state law enforcement and regulatory agencies. This may be your priority, but if we're waiting for information, for example, from the Nevada Gaming Control Board or New Jersey Gaming Enforcement, SEC, federal law enforcement, it just doesn't turn around as quick as you might think.
And not just domestic, but, these are companies, not just the companies themselves, but again, the financial sources and investors and associated companies that are international in scope. And if there's some information about business practices in a foreign country, that you can't just pick up the phone and find that out overnight. It takes a while to go through the channels and the processes to try to obtain that information.
And then not only do you have publicly traded companies, but you would also consider the possibility of private equity companies, and their structures are quite different and unique, and sometimes difficult just to look at from a spreadsheet type of situation, but then you have to determine who within that framework has to come in and whether or not they want to expose those sub-companies and groups.
And lastly, local partners and so forth that have not, for example, been involved in the traditional gaming background process before are now hit with relatively sophisticated forms that they have to fill out for the first time, which engenders questions, delays, and research. So that in itself can engender some delay.
All that said, we're not suggesting that you have to reinvent the wheel here.
Yeah.
If there's information that's been gathered in the past about any of the applicants or any of the people who need to be investigated in connection with the applicant, all of that will be utilized. We're not going to create, start from A to go to Z if already some people have gone to D.
But to pick up on Mr. Carroll's point, and we are seeing evidence of large operators who do have this tremendous background and experience working with background investigations, but we're finding more local partners. Is there something the commission can be doing to help these local partners make that end of their investigatory process easier to help shorten up some of these timelines?
Well, we have found in other jurisdictions that if there was a meeting to brief the applicants on the process and the application form right at the earliest possible stage, not that their joint venture partners haven't done it, but to hear it from the regulators and the investigators perhaps is a way to accelerate the process. In other words, don't submit an incomplete application form. Don't submit information that, is not supported by appropriate paperwork or other documents. That process can be helpful to a company who has not been in this process before. There is no doubt that Caesars or these major publicly traded MGM can produce a computer-generated application and supplements and everything in days.
Well, one other possibility, and I don't mean this as a plug for our profession, but if you do retain experienced gaming counsel, it does assist in the ability to go get through the process. Their advice and their counsel in aiding you by telling you what to expect would be worthwhile.
But to Fred's point, should we build in that kind of educational period or week as part of the
And then
timeline?
springboard into the scope of licensing. Use that as the springboard into the scope of licensing.
You've also, this commission has already taken certain steps. You've made the extra effort even in putting together the applications that have specimen forms and detailed instructions and so forth that is going to be helpful to the novice or the first-time filer. But even in addition to that, you can have educational sessions, and frankly, the availability of commission staff to answer the questions are important. And we've always had ongoing discussions about policies and so forth. The clarity of the policies and the scope of the policies are important so that everyone understands. The gaming applicants, know. I mean, they know what the industry standards are and so forth, and then the Massachusetts nuances and so forth are being made known if they haven't been already. But the newcomers, there is everything to be gained by education at the earliest stage so that when they file, like Fred says, it's complete, questions are minimal, and you can move ahead with the background investigation in a thorough format.
The starting and stopping of an investigation, waiting for information that should have been provided at the front end is, from our perspective, an unnecessary hold. But the more that can be eliminated or minimized, then that will speed up the process.
I think that's a really good point, Commissioner Stebbins. And we will have an ombudsman on shortly, and that person could have the job of reaching out to what we understand to be local, particularly the local bidders, and make sure they're looking at the forms and starting right now. I think that's a really good idea. We could help on that. Presumably, the gaming folks are getting their local partners to do this, but we could take a role in that. I think that's a good idea.
I want to ask one more question that relates to timeline, but it's certainly part of the strategic plan and has the two options relative to the timeline. And that has to do with the slots parlor license, which what we have currently represented here is the assumption that we would eventually bid all and investigate all concurrently, and perhaps to comply with the statute, let out the RFA for the slots parlor license first, thus complying. But whether, my question is whether, and I know we've talked about, I have talked to a couple of you individually about this, but for the benefit of everybody, as to whether letting out the slots parlor license first by virtue of drafting regulations to that effect that would enable us to do that in order to really advance the schedule, whether that is realistic or not.
Yeah, very much so, and it ties to what we had spoken about before, about prioritizing the regulations. That would be a kind of a sub-priority. When we get to the point where we are drafting rules of the game and so on, we would focus, it would be worthwhile to focus first on the slot machine rules as opposed to the table games, so that a slot parlor could, call a slot parlor, a slot licensee, could open earlier. That doesn't mean that we would ignore the table rules. We'd do those as simultaneously as we could, but there'd be a priority in terms of the ability to do that. That's when the time saving would come in. In terms of the investigation itself, that takes whatever it takes. It would be no different for the slot license or the Category 1. But the actual implementation of, there's less to review for the implementation and opening of the license than there would be for Category 1.
There are, however, regulations that concern every type of gaming operation that you would kind of do at the outset. So you do the ones that cover everything, and then as you go down and you start to prioritize, you could probably next tee up the slot regulations and get that moving, and then you do the ones lastly that are the more full-scale gaming that come along later. So you do the broad ones that cover everything and then prioritize as you go down.
I agree with that point. I was actually going to see if there was a way to somehow break it out in the timetable. Obviously, there are regulations that are going to be germane both to a resort casino as well as the slots parlor license holder.
Is that that's another thing, I don't remember that you've done that. Is that?
No, we're gonna,
Yeah.
But I think we will.
Okay, good. So following up on this. Okay.
yeah, we're gonna follow up on the
Okay.
aspect of identification, bundling of specific regulations for different portions.
Quick question relative to MOUs that we're required to have with other agencies, kind of factoring that into the timeline as well, because obviously key to that is its connection with investigations. And something to think about further down the line is we've talked to a number of area communities, or what I categorize as local MOUs between a gaming operator and the local convention visitor bureau or any other number of entities, and just kind of flag that as to is the phase 2 regs start to get pulled together, kind of how those get pieced together. So this commission has the opportunity to give them teeth, or how we can give them teeth at the full license application process. So I guess it's two categories of MOUs. One obviously is more particular to us.
They might be in the nature of MOUs, they might be in the nature of regulations that address the elements of a community agreement, host community agreement, or surrounding community agreement as well, or both.
We're ready to switch into anything. I think we're going to talk about the investigations step mostly, I think, later after the consultants have left. But certainly, it goes without saying that this re-raises the criticality of getting the Bureau up and running, because the Bureau, all these things has to be done by the Bureau under the statute, and I think we understand that and take that seriously. Anybody else jump in if you've got questions that either came off the questions that you raised that you want to bring, or any kind of other feedback? I've got a series here, but I'll let other people go first.
I know from something that you may have articulated earlier had to do with tribal gaming impact on the plan. That was a general question that surfaced, and one that I would like to pose. The current draft of the strategic plan is somewhat silent, shall we say, on some of the implications of that region.
Right. I'm not quite sure, I'm not sure how many, I don't think anybody really knows what the answer to this is, but it's got to be acknowledged in here somewhere and raised in our sensitivity that there may not be a third casino for a period of time while the land and trust issue is resolved. B, once it is resolved, there's going to be an Indian Gaming Commission, and how much of what we're planning to do will not be necessary, et cetera. So I agree, attending to that is important.
The compact, Chairman, also sets forth numerous responsibilities of your commission in terms of relationships with the tribe's regulatory agency, the interaction between tribal and local law enforcement. The tribe has a challenge, set of challenges ahead of it. It has to organize a lot of these critical infrastructure elements that'll be part of their regulatory, their law enforcement, and their overall administrative structure. I'm sure those are being fleshed out in the process that they're doing now in their development. But once those processes are up, there is bridges between the compact and the state that are going to have to be addressed by the commission, as well as other state agencies that are going to be critically important. The amount of resource and asset that you're going to have to devote to that is unknown at this point. A lot might develop on what the tribal structures will be. But the compact does have a framework for interaction.
Right.
The regulatory authority, the primary is certainly the tribes, but what that structure will be, how it'll work out is going to take discussion, and I would say somewhat aggressive discussions between the state and the tribe so that all of the Commonwealth's issues are protected. The tribes, in our experience nationally, work very hard to make sure that they're compliant. And I think it'll be a cooperative effort, but there is going to have to be asset and resource, and that'll be fleshed out over the next few months as the process goes. And of course, the land and trust is looming over everything at this point.
Right.
Well, the compact process is moving forward. The land and trust may well take longer, but how has this worked in other jurisdictions? Because it seems to me that there is an interface between our regulations and the tribal regulations.
Mm-hmm.
There are certain responsibilities and veto powers and approval powers that we have, and certain standards that we will apply to ourselves that we will want to see, perhaps, and this I'm talking theoretically now because we haven't started the process, applied as yardsticks for approving or not approving some things that the tribe does. How and when should we begin the process of dealing
This
with all
compact's a
that?
little different.
Right.
Each compact in each state's different. The role of the state regulators here is different than other states. For example, in New York, there's concurrent jurisdiction with the state regulators.
Right.
There's state police in the casinos. The state does the licensing, background investigations. The tribe does the day-to-day compliance. So each state is different. This compact sets different standards for this commission in terms of its review and its approval process. And I'm not sure what the appropriate time to begin those discussions are, but until the land's in trust, that's a good starting point.
Yeah, I'm not sure that, again, there are no clear answers to this, but that you need to wait that long. There certainly nothing can actually be implemented and done until all of the steps are taken.
Right.
But the cooperative relationship as between the state commission and the tribal commission could begin as early as possible, as if there is a tribal commission, if there isn't, the tribal government, just so that there are bridges built and communication opened, so that if in fact ultimately it becomes a reality, you don't have to start from scratch at that point.
And part of it, I could add, and this is assuming, and I would say with a high degree of probability, that the tribe will retain qualified, experienced people in their regulatory system. When that's done, the discussions that will be had will be like, for example, if the tribe actually performs the initial background to issue a tribal license to an employee or to a gaming manager, then your commission will have input into that, whether that would be acceptable, and can make an objection to that. But what is the degree of investigation the tribe will do? Is that satisfactory to this commission? Are they applying the standards that you would otherwise apply? And once that decision is made, You know, how is the approval process, or say disapproval? What is the process between the tribes, the tribe and the Commonwealth? But all of these things, I think, would be premature now, but when the tribal infrastructure starts taking place, starts taking shape, you know, I think I would keep a careful eye on continuing those discussions and having some liaison with the tribe so that if the thing moves more quickly than expected, you would not be in a position of having to play catch-up. Right now, there isn't a lot you can do, but there is certainly absolutely compact responsibilities that the state has or the Commonwealth has that will have to be addressed and addressed in a pretty thorough fashion, I might add.
Just to put a fine point on the question of developing relationships, it's no surprise and need not be repeated that tribal entities in this country have sometimes or experience a natural kind of difficulty in a trust relationship with outside persons. And the sooner you can develop that trust, the better off you'll be in your future discussions in terms of being able to implement and work cooperatively with those procedures.
We are reaching out to the tribe to begin the relationship building right now. But I certainly agree that, you know, as I remember, it's been a while since I read the compact, but it looks to me like if our commission and their commission don't have really hand-in-glove working relationship and similar standards, then we're gonna have to do everything twice, which is gonna be incredibly inefficient and expensive. So it's developing that relationship and hoping it merges really well is huge, I think. Okay, who else? Other questions? Okay, I've got, yeah.
I got just a quick question when we contemplate, again, this is kind of a little item, but obviously in our org chart, one of the things that we've had recent discussions at our meeting is about taking the initial steps to appoint necessary members of the gaming policy advisory committees and the subcommittees. A lot are designated in the statute. We all know that some of those seats are set aside for host communities, but figuring out their relationship either directly to the commission or to the executive director. They are an advisory body, but you know, if we're going to utilize their time and value their opinion, structuring where they kind of fit into our organizational structure, I think is key.
That's a good question. Yeah, it's not even mentioned in the draft, I don't think. Others? Yeah.
Do we have, on a slightly different vein, but still on a do we have it, do we have I know we have a number of entities with whom we need to have MOUs in order for us to carry out our activities effectively. Do we have a comprehensive list now of the entities and the kinds of MOUs we need in order to move forward?
We go ahead, provide.
Yeah, Commissioner, we have worked on that. In fact, as recently as today, we met with the state police in order to discuss some of those things. The statute requires an MOU between the state police and the local government regarding law enforcement. That would probably be tied also to the local, the host agreement for funding and some other issues. Beyond that, in terms of the MOU structure, we've discussed it with the Attorney General, and there may be may not be some need for MOUs between the state agencies. That can be worked out from agreements and policies and so forth, some which may be in existence already. In terms of external MOUs, there will be some that will be required of law enforcement and regulatory agencies. Now, they can range from being very informal, if we want to exchange information and so forth, giving assurances as to confidentiality of information supplied. Right. In terms of a list of each and every agency, I would say no, we haven't yet prepared that, but we certainly know the categories where we will need them, or many of the particular agencies that we can identify very quickly. Within Massachusetts itself, the particular MOUs that come to mind right now would be related primarily to law enforcement.
Gaming regulators.
Yeah, but I mean, within Massachusetts, I think, I think primarily law enforcement at this point. There is some other provisions in there that relate to MOUs, but we'd have to go back and check each one item.
Okay. In terms of, it was the bridge building in advance of the need discussion that made me think of this. And it seems to me that we probably can do some of that independently, but would welcome your help in identifying them so that we could at least reach out to entities, even if we're not actually ready to enter into the agreement, and say, we got this thing coming down the road and we're going to need to work with you to get it done. The earlier we start that, I think the better it'll be when we get to the need to actually put pen to paper and do an agreement.
And some of it is, excuse me, Fred, some of it is also introduction of your system. And only, not only you as commissioners, but introduction of your system. And there are events, I know some of that will be taking place very shortly.
Right. Sure.
To pick up on that is, some clarification from Commissioner McHugh. Are we talking about potential outside governmental bodies who can help us with the Phase 2 application, assessment, scoring, evaluation? I mean, does it behoove us to, and we had a conversation about this at our Springfield Forum, whereby regional planning authorities have a role in reviewing environmental policy permits from large-scale projects. I mean, those types of groups.
Absolutely.
Obviously not on a long-standing basis, but certainly for that evaluative phase.
Absolutely. We're not just talking about pure gaming type and law enforcement type agencies, but as you get into the evaluative process of the facilities themselves, like environmental organizations, in planning boards, zoning and so on, that would be necessary for you to make a judgment about the facility itself.
Fire marshals, for example, variety of different agencies.
Transportation.
Regional DEP,
Yeah.
Environmental Protection Law. Okay.
On this same vein, there's a reference in the draft to MGC needs to make, get introductions to, quote, key gaming regulatory agencies. Are you talking about other states?
We're talking about other states.
Okay, because so we'll be meeting some of those folks in
Yes.
Las Vegas, and then Commissioner Cameron and I are going to Singapore, and you're going to help give us some introductions there, which would be really helpful. Anybody else? I mentioned just briefly, but I want to make sure that it's put on the record, you talked about managing credit as a means of protecting the casino, but there's not really the mirror image, which is managing the way that the casino operator manipulates or doesn't problem gamblers or protects problem gamblers. And it talked about bounce checks being a way to protect the casino, but it's also a way to protect problem gamblers. I just think we'd like to see both sides of that.
And we want to expand that in the
Okay.
table of organization proposed. You saw there's a professional position for socially responsible gaming, which dovetails exactly into what you're saying, and that definitely needs to be broadened.
There was on the org chart, which is another issue, I'm not sure that we really need to spend a lot of time talking about this with you, but we clearly have an ombudsman already, which is apparently a role which doesn't necessarily always exist. And we are thinking seriously about getting somebody who will be in the workforce development, small business promotion, diversity, supplier diversity, et cetera, area. So I don't know if you might want to put those onto the chart somewhere as well.
Yeah, absolutely.
And since we're talking about table of organization, we had also earlier discussed the notion of CIO or an administrative type information technology.
This one is one that I do think it's not urgent, but it's getting close, and maybe this is worth sort of talking a little bit about our different ideas. If I remember it right, you separated the sort of the technology that has to do with the management of the casinos and the managing of their cash flow and their game approvals and so from their internal operations of the commission. And I think Commissioner McHugh, you've thought a lot about what kind of a structure. I think it might be interesting to sort of exchange with the consultants a little bit on how they see that. How do you see it?
Well, I'd welcome that. I noted that when I reviewed that, and it seems to me that that I started with the proposition that the Chief Information Officer is a technically adept visionary policymaker. That he or she is a hands-on person in terms of organizing and having control of things, but also as somebody who is at the director level, who is familiar with and able to deal with emerging trends, emerging kinds of technologies, and also think about the business processes that those emerging technologies will serve and how to change the business processes to take advantage of them. And that person is the kind of person we want to be the CIO, and that beneath him or her, you have the gaming technicians and the internal document control technicians, and everybody else flows from that position. But that the CIO is not a technical person in the sense that we think of a backroom computer operator or somebody who knows how to hook up the various workstations and make the network sing, but knows how to get others to do that. And I just welcome your thoughts on that, because you did split up the two functions.
And we agree that, this is potentially and really a critical position, because both the industry and the governmental agency that's overseeing the industry is moving to be more technologically dependent on these types of systems and what's ever coming down the pike. And
Right.
Mr. Bowman, who worked on that with us, is going to sit down and expand that and give you some additional thoughts.
On a broad conceptual level, there would be no organizational difficulty. I think the bigger hurdle in organizing the commission that way without the split would be finding a person who was that knowledgeable enough in both the standard business areas and the very unique types of needs that a casino operation has, to be in a position to be able to supervise those who are evaluating the casino's technological operations. We're not just talking about mass information and data processing, but we're talking about electronic games and slot machines and all of that that are of real specialty. And if there were a person who was capable of, knowledgeable in all of those areas, we want to draw on that expertise, that's for sure.
But you say if, so is that not a familiar model in other commissions?
I don't think so, but
I think of most banks and most major corporations now have a CIO, but most universities have a CIO who's at the director level, doesn't know all the details, and there's highly specialized kinds of computer operations that he or she oversees. Think of a university with the kinds of things in the research and areas, the technical areas. But the CIO has enough vision and organizational sense to keep all that under wraps. Well, why is the gaming industry different?
Well, I think
historical?
I think historical. Some of the agencies have been set up years ago, and they've evolved in a different direction. And
Right.
some of them, for example, used to have testing laboratories within the framework of the regulatory agency, with one or two major exceptions. That has now changed with the use of the outside laboratories. The accounting systems and all of those things that are used in the casinos are usually audited and subject to governmental approval and review by regulators, but the two disciplines haven't married yet or come together. That doesn't mean it can't or shouldn't,
Right.
but it just, by process of evolution or devolution, hasn't happened.
Right.
I can say, you have a unique opportunity with your commission in as much as you're ramping up right now. If you want to set up that structure, and if you can figure out the person and how it sets up that way, it would possibly be beneficial to you. But take a state like New Jersey, started in 1978, it had its own structure, and when New Jersey began, there wasn't a lot of technology.
Right.
So technology came and was inserted on top of an existing system. So as technology advanced, the pipes came in different areas because the financial reporting started to become a little bit more electronic, and compliance became a little bit more electronic, and employee licensing and vendor licensing became electronic, but you had a bunch of different trunks that the information was coming in. It wasn't funneled to one source and managed. It was kind of, each person knew their own technology in their area, but it was never really synthesized. If you have a situation where you can synthesize all the information and have one person who knows it all and then has assigned its duties where the responsibilities differ, then that would be great. But setting up that structure and finding that individual may or may not be a challenge, but it's something I think that we could
Absolutely.
incorporate into a plan, and give you an IT plan that considers that situation, if that's your desire.
And some states are moving toward online gaming, either through the lotteries or through the gaming commissions, and that is, to a degree, unprecedented in gaming, much more reliant on technology.
Right.
So whether it's going to go kicking and screaming or whatever, it's going to happen.
Yeah, and see, I think we all recognize that in 10 years, the technological piece of this business, as well as everything else that we do, is going to be a dominant piece. And we need to be planning for that now, I think, because we are, as you say, we are, Mr. Epps, a new entity, and we're not trying to pile things. We have the freedom of not having to pile things on top of an existing structure. So
I think you're absolutely right. It's absolutely the presumed way we'd want to go. I mean, maybe you can't find the person, but I think it makes all the sense in the world to try that. So addressing that a little bit would be helpful.
We intend to.
You have over the months mentioned areas where you recommended legislative fixes. So if you could pull those out and give us a list somewhere, that would be helpful. We talked, I guess, quite a bit now about pulling out and speeding up issues that are necessary for licensing. We talked about the Category 2 license earlier. Do you, as you know, the law says we have to put out the RFP first for the Category 2 license, but it doesn't say license first, it just says put out the RFP. Is there anything, any reasons? I mean, there's pressure to get started. People want to start the jobs and have the gambling accessible and get the revenue and so forth. Other than those pressures, are there any structural reasons to consider either doing the slots first or not? Is there any market impacts or?
Well, it gets revenue into the state, quicker.
Right.
And the construction period for building a slot licensee in an existing facility will be much shorter than constructing a new facility, from scratch, considerably shorter. So there are, policy reasons and practical reasons and legal reasons as set forth in the Act to do so.
The only, and this would be a minor factor, I would think, but maybe a factor, is that depending on the location of the slot licensee, if it was going to be in some area that might be competitive with the Category 1 licensee, allowing it to open months before the Category 1 licensee might be some competitive advantage that would warrant some consideration of whether it should be done or not. But other than, it's just an initial reaction. But we would think overall that the sooner it could be done, the public policy would be better served.
I suppose this, sort of a corollary to that is we presumably will want to be thinking about the locations within the regions, and there are implications for a slot parlor being near or far to the casino, and so for us to make a decision on a location of a slots parlor, not having yet made the decision on the locations of the casinos that could be nearby, that might.
That's right.
Yeah.
And in Ohio, we're seeing racetracks moved.
Oh, really?
Yeah, they will go with 3 or 4 of them.
Right. Okay, org chart. Oh, revenue collection manager. You had recommended that the revenue collection manager be a near-term hire in the same list that we're now doing with the GC and the director of the IEB and so forth.
Yes.
What's that about?
Well, with the application process beginning, there'll be money's coming in for the investigations, for the qualifiers, for changes in company structure, and we felt that those accounting systems and that position would be overseeing that in a way, that they would long-term, but since that's going to be happening relatively soon, that function should get up and running as soon as possible for the commission.
Okay, so you're basically talking about the licensing, the application fees and its allocation, so.
And then following that, yes, you have the construction licensing coming up and
Well,
everything.
that's
Yes.
a little while though, right? That'll be a ways from now.
A year,
Pardon?
a year or
Yeah,
so.
right, okay. Okay. This is something that we've talked a little bit about. We talked going way back at the first education forum that Commissioner Cameron and you all put together. But I'm struck reading the materials about the direction that you recommend that we take steps to assure that the casinos don't get robbed by anybody. Card cheats, robbers coming over the walls, whatever. And explain to me a little bit why it's our job to make sure that they don't get defrauded by MIT students. Wouldn't that be something they would be taking care of themselves? Wouldn't they have a higher incentive than we to do that?
Of course, it's clear, obviously, you're right, they do. The casinos and the state have a joint interest in making sure that the casinos are well-run and efficient and honest. The institutional justification for gaming regulatory agencies and their role in the process has traditionally been and continues to be that from a purely business standpoint, a casino, and justifiably, there's nothing illicit about this, a casino can afford to absorb a cost-benefit analysis, some loss, as a result of maybe looser controls than you might otherwise think is optimal. The state, on the other hand, can't. This not because of a financial concern in tax revenue as much, but because of the image and the impression and the public perception of the fact that the casino is well-run. If a player comes to a blackjack table and he sees some cheating going on, it may cost the casino a couple $100. But that player will go tell all their neighbors and everyone else they talk to about how illegal the games are in that casino and in Massachusetts generally. Or they'll probably take that impression away with them. So it's because of you certainly have a joint interest. We always say when we make give these talks that, nobody bets on professional wrestling. The games have to be perceived as honest and perceived as well-run to a greater degree than they actually are, although they certainly will be honest and they will be well-run, but the degree to which the casino can afford to have some slippage is different than the degree to which the state can afford to have that slippage.
Is there really data on that point, Guy, that that the casino weighs cost of verification and integrity versus a loss, a percentage loss?
The prime example is staffing, for example. The casino will, the operational costs will be reduced by lower staff, maybe in security, maybe in surveillance, maybe even in levels of supervision. And, it's a business decision. And when you have that kind of lesser observation, the essential control of a casino is people watching people watching people. And if you have fewer people watching, more things happen. And as a result, a casino will legitimately say, we can't afford to have this many security officers, and we can't afford to have this level of supervision in a pit. But the state, at times, will have to say, that's unfortunate. When it's a balance, the state can't be overly regulatory. But the state, at times, would have to say, you're just going to have to absorb that cost.
When When I first met you guys as a group, one of the things I said to you is that you have two responsibilities, and that is A, to protect the revenue, to make certain that the state gets the revenue that it's supposed to get, and the other, so that's where you protect the citizens of the Commonwealth, and the other is to protect the guests of the industry who are coming in, to make certain that they're gonna play a fair game and have a fair shot. Those are basically your two overarching duties. You make sure you collect the proper revenue for your Commonwealth, and you make sure that Massachusetts gives a fair game. And sometimes you have to be more vigilant than you might think you want to make certain that those things are done. Because left to someone's own devices, less is more. So you have to make sure that you've got the right level of oversight to make sure that your mission is accomplished.
I don't want to leave the impression at all that the casino doesn't care. The casino cares greatly. Their image is just as important to them as being honest and being well-run as...
They don't have any more interest than
have
we
this-
would in the guy going out and saying, hey, I ripped him off $200.
Exactly. Don't go to that place. They don't have an honest game. That's absolutely true. There's no intent on the part of the casino to be anything but honest and well-run. But sometimes business dictates that some controls are lessened to the point where more risks are taken than the state may otherwise want them to.
And the equal application of those rules to all players, the person who's playing a slot machine, the person who's playing a table game, and the person that has, a high level of credit in the casino, and to make sure that it's done fairly and equitably.
Steve, if you'd like a concrete example of that, would be, for example, the surveillance cameras. How many cameras would be fixed? How many would be movable? What is required by the commission to make sure that the slot machines have proper surveillance coverage? What is the staffing of the surveillance room? How many people would be available for live review and support? These are the kind of things that come in, maybe become a financial or a budget issue, but the commission's going to enforce minimum standards. They're going to make sure that the considerations and the protections afforded to both the patrons and the regulatory system as a whole are maximized. And the casino may feel it's, cost efficient to cut down, but you won't allow that in many areas. And that's where the balance is struck.
Okay, interesting.
We have another example, the financial industry, but that's besides the point. Too big to fail, something like that.
Yeah,
Too big to fail.
good point. I had one last thing, which is sort of a technicality. Does anybody remember well enough in the law, do we have to have our bureau, the IEB, up and running at the time we release the RFAs? RFA 1?
I don't think per se, but by the time...
As a practical matter, pretty close to it,
Yes.
but I just wondered if there was some technicality.
But at the other end, when the investigations are prepared for the Bureau.
Right.
And they issue their report to you.
Right. Does the Bureau conduct the qualifier scope of licensing conversations?
We would intend that they would participate. There's no statutory requirement that they do so, but the sooner that they do get involved in the process, the better.
Okay.
One of the large questions that I wanted to, or big picture questions that I wanted to throw out was just next steps from the draft that we have received, we have read, and it's lengthy and there's a lot of great information. But wanted to just start a conversation as to the immediate next steps, if you will.
In our view, the next step is getting the scope of license, from the licensing side, getting the scope of licensing process started, figuring out who has to apply, and then moving forward into the investigative process, while simultaneously the Phase 2 regulations are being discussed and ironed out and published, so that by the time, whenever the investigations are completed, those regulations need to be in place so the commission can then move forward on the evaluation of the competing projects and ultimately make a decision.
And a finalized version of this plan.
No, well, that goes without, yes.
And the final promulgation of the Phase 1 regulations.
Right, which I think we're on track for.
Right.
So you had talked about having scope of licensing meetings and kind of introductory meetings with all of the applicants, basically immediately upon release of the form, right?
Correct.
So if we hit, was our date, October 12th, was our target date, I think, for the release of the RFA one?
Yes.
So if we're going to make that deadline, we might want to start setting up those meetings fairly soon.
Yes.
Fine. Those entities that have already applied, we certainly reach out for. Those that have not applied can reach out to the commission and express their interest.
Right.
Chairman, to answer your question, I don't see anything in the statute in regard to that, requiring that.
IUB, okay. Okay. Great. Anybody else? Feedback for the next draft or questions that we really do need to get into right now?
I'm still shocked by Guy's comment that professional wrestling is fixed. I'm gonna pass that. I've lost a lot of money on Hulk Hogan with this.
I have a family member who actually writes and produces for them, so we can tell you some stories.
Writes and produces, that's all right.
He does, yeah.
Just thinking about kind of the next phases in a question that kind of keeps popping up and how we as the commission might be prepared to address it is, the notion of phasing of construction, phasing of option of temporary facilities. But, the $1 billion investment, well, at the end of the day, we find out the $1 billion investment is stretched over, a certain number of years. Obviously, we're mindful of the temporary jobs created with a construction project and the full-time jobs. So giving some thought to those scenarios. I mean, balancing them, if it's realistically because of where the investment market is, that's understandable, but kind of looking at those scenarios.
Okay. Well, you're looking for them to address that in the strategic plan?
And
I think in the Phase 2 regulations, they will clearly be issues that will come to fore and have a variety of discussions.
Anybody else, Commissioner?
I just wanted to come back to the Bureau thing. I do think the Bureau has a role. Section 12 says, upon receipt of an application for a gaming license, the commission shall instruct the Bureau to commence an investigation. So I'm not sure what the point was.
Well, I meant at the time we released the RFA, did the Bureau have to release the RFAs? And that apparently, the answer to that is no. But as soon as they start to come in, which could be as soon as a month or possibly, so.
Oh, I thought there was an ambiguity as to whether the Bureau was the investigator. The Bureau is
No,
the
not at all. Just when they had to be.
I made that
Okay.
point, that's an important point, that I know you know that, but the language needs to, whether the Bureau outsources assistance or not, it's the Bureau.
Always the Bureau.
Right. Okay, I think we're all done. I think, I've said this before, but it's one of the nice things about the product that you are working on, is that it's very readable and very easy to use, and that is often not the case. So, it's a very nice job, and it's going to be a great tool for us. And combined with this, we will really have a way to manage what we're doing and communicate with the public about what we're doing. So really appreciate it.
It's clear, though, that it ought to be clear to everybody that remains a work in progress. It's not a final document. It's a document being developed for use of the commission and subject to revision and a lot of steps before it's finished. So it's something that we're working on. But notwithstanding that what we've seen thus far is, I agree.
And then when we finish it, to get it essentially finished, this will become a public document. But it's not until while we're still chewing on it.
And thank you for all the feedback and all of the very worthwhile questions and assistance that you provided to us.
Thank you for all your great work.
Thank you.
Thank you.
Thanks.
Don't bet on the Iron Sheik either.
Don't bet on the Patriots.
Ooh.
Okay. We talked about, item 3B is out-of-sequence policy decisions. I think we've talked about that, right? That's, Commissioner McHugh, you had really brought that up. And I think that's what we were asking them to do. To pay attention to. I think it is something that we can be thinking about as well.
Right.
but I don't know that we really need to spend any time talking about it at the moment.
No, at a meeting, I think we talked about trying to get a list, and I think that Director Glovsky and Kristen Gooch are going to be working on that as part of the protocol, and I thought that next week, while you're in Las Vegas, that I could spend some time going through the statute again and trying to isolate the policy decisions.
Okay, that'd be
where
great.
you have to
Okay.
make.
Okay, Phase 1 regs. Commissioner McHugh.
All right, you have a large group of documents there before you, some of which you got today, and I regret that, but what I thought I'd do, simply explain what they are, and then go through and hit some highlights, and then be prepared to answer questions. So we have three basic documents in front of you now. We have, first of all, a matrix that incorporates all of the substantive comments that we received up through September 10, which was whatever the deadline was for receiving public comments for the draft regulations. And
Can I just interrupt for 1 second? Do you want the consultants to be here for this conversation, or is this a conversation that's among the commissioners?
this is, the consultants are welcome to be here, but they, yeah, I don't think we need them unless any commissioner feels that we do. Yeah, I mean, they've been done thorough and helpful service with respect to the preparation. So,
Thanks.
the first document is this matrix. On the matrix, every comment we received has been recorded. The comments have been broken down so that they relate to a specific section, and in some cases a line number, on the draft regulations. And then there's a recommendation that is made to the commission as to whether we should accept the suggested change or not. And that recommendation represents a consensus in almost every circumstance of the legal and the gaming consultants. And so that's the first document that you have. The second document that you have is another matrix that is directed to what one commentator called typos and matters of form. It takes the same form, it breaks down those comments, attaches them to the provision of the regulation to which they apply, and comes up with a recommendation as to whether they should be accepted or not. That document I distributed this morning or yesterday, and it's a shorter document. That, I think, Commissioner Zuniga, is the big document, and the one in your hand now is the smaller document that refers basically to typos. There are some substantive comments in there, notwithstanding the fact that it was aimed at typos. The third document that you have is a red line version of the regulations in which virtually all of the comments in both matrices have been changed. That is, wherever there's a recommended change, that recommended change has been incorporated in the red line version of the regulation so that everybody can see the context in which the changes are made and exactly what they say. So the idea now will be that if the commission approves not that red line version, because there still will be some more typos that have to be corrected, there still will be a couple of other things that have to be changed, but they're minor changes. If the commission approves the changes recommended in the two matrices, then the technical work of making sure that those changes are carried over into the draft regulations will proceed over the next couple of days. We will then have a draft that we will submit to the Secretary of State for publication on Friday. It will be published 2 weeks from Friday. The final regulations will be published 2 weeks from Friday. And then we can issue the RFA 1 2 weeks in the middle of the following week on schedule, October 12th. Before I go into the a few highlights of the first matrix that I wanted to invite your attention to, I should tell you that there's a parallel process going on with respect to comments on the forms that we are going to use for the RFA 1 process. Those forms were published. They do not have to go through the process that that these matrices reflect, because that process is driven by statute and is required for promulgation of all permanent regulations. The process for approving the forms is not regulated by statute. That's our own process. But we put those out for comment, and we've received a few comments. And I'll be prepared to present to you those comments in similar form 2 weeks from today, and that'll be plenty of time because we can simply make the changes without having them published. So that's yet to come. So with those thoughts in mind, let me go through, if I might, very briefly, a couple of issues that I think are worth considering in the first matrix, the large document that you have, and invite your attention to a couple of aspects of that and what the changes represent. The first is on page 6 of that document, and it refers to section 102.02, although the recommendation deals with a different section. Basically, the thrust of the comments there is that the ban on political contributions that exists in the draft regulations is overbroad because it prohibits contributions to committees set up to support or oppose referenda and federal offices and office holders, as opposed to state people running for state office. And it is really only people running for state office and municipal office that the statute says are prohibited from accepting that the applicants can't give contributions to. And there are constitutional problems, First Amendment problems, with prohibiting contributions to referenda committees. So that the change recommended, although in technical language, is designed to narrow down the prohibition so that it meets both statutory and constitutional considerations insofar as contributions are concerned. At the same time, the regulations require, as does the statute, a disclosure of all the contributions that are made, whether they're made to individuals or committees, and that comports both with the statutes and with the Constitution. So we've narrowed down the ban on contributions, but kept a broad requirement for disclosure of the contributions that are made. The regulations that we've issued on this subject will complement the regulations that the Office of Political and Campaign Financing has issued dealing with the same subject. Ours are a little broader. Ours require a disclosure in the forms, the RFA 1 forms, for example, all contributions that have been made since the statute went into effect. The Office of Political and Campaign Financing does not have any look-back provision like that. So in some ways, we're broader than they are. But once these regulations are adopted and effective, we, I think, should reach out to them to see and make sure that we can share information so that everybody has the information that everybody else has and can use it to their best effect. And Commissioner Stebbins and I talked briefly before this meeting about that, and I think we can arrange to do that. So that's the first thing that I wanted to point out to you, and I'd be happy to stop there and take any questions on that subject if there are any, or answer any. And if not, I'll proceed to the next one. All right. The next one is on page 13. And that correction is designed to remove an ambiguity in the regulations insofar as they deal with confidential information. The regulations' approach to confidential information requires careful reading by all who are affected by its provisions, because it's designed to deal with two kinds of confidential information. It's designed to deal with information that is explicitly made confidential by statute. And there are a number of provisions, and they're in the regulations, where you move directly to a statute, and the statute says this kind of information is confidential and it's easily identifiable. CORI information, criminal offender record information, is one kind. That's easily identifiable. It's defined in the statute. You know what it is. The regulations also deal with another kind of confidential information, and that is the information that we have considerable discretion to define, and that is business, trade secret, competitively sensitive information, trade secret information, and similar information. And the statute gives us the power to deal with that as confidential, and the regulations do so, and they do so by defining what's meant and then combining the definitions for all those subparts into a single definition of confidential information. The way the regulations were written initially, there were some ambiguities with respect to the steps one had to take to assert a privilege and an objection to disclosing the statutorily defined confidential information and the stuff we defined as confidential information. These changes are designed to remove that ambiguity, to say that if the information is confidential, either because the statute says it is or because our regulations say it is, people have a right to say, we don't want that released. And it shows the mechanism for doing so. And that's what those changes are designed to affect. So that's the second category that's worth bringing, that I think is worth considering. The third deals with community reimbursement, and it raised
Where are you? Which page?
I'm sorry, page 19. The third set of changes deal with community reimbursement, and they raise two issues there that are worth considering. The first is this, and we've received some commentary about that, and it dovetails with a memorandum that Commissioner Zuniga has prepared, and I think we'll discuss here in a minute. The regulations right now say that if a community wishes to obtain a portion of the $400,000 application fee that an applicant is required to deposit at the time the application is submitted, if a community wishes to obtain a portion of that fee, the community and the developer will submit to the commission an agreed upon a document agreeing upon the disbursement, and upon receipt of that, the commission will disperse the amount described in the agreement. There have been some suggestions that if there is no, that's unduly harsh and burdensome on communities, because if there is no agreement, there won't be any disbursement. So things are really in the hands of the developer. And for the moment, that's true. The Phase 2 regulations will go beyond that and will deal with the situation in which there's disagreement. But at the moment, there's no standards really for the commission to use in making a judgment about how to resolve the disagreement, because there's no measure, with no plan in front of it, with no proposal by the developer in front of it, with no idea of what the dimensions of the proposal are. At the moment, the commission has no standard for evaluating the reasonableness of the expenses, non-agreed upon expenses, that the community wishes to obtain. And so for the moment, but in order to facilitate, even at this early stage, getting some monies into the hands of developers, into the hands of either host or surrounding communities, this agreed upon measure is the one we've promulgated in our draft regulations and in our final regulations if this carries through. There is no prohibition, of course, on a developer and a potential host or surrounding community agreeing on a payment by the developer directly to the city or town to facilitate the mitigation effects or the negotiation effects that the city or town needs to have funds for. That disbursement has to be disclosed. There's a provision in the regulation for that. But there's no ban on the direct exchange of those kinds of payments. So these regulations only apply to a city or town's effort to obtain some of the money from the $400,000 application fee that an applicant pays the committee, $50,000 of which is, by statute, set aside for mitigation and negotiation by host and surrounding communities. So that's the first change.
Just
And-
on, could I just, on that?
Yeah.
I think I had a different feeling when I first read this, but hearing you talk, I think that makes a lot of sense. And it should be pointed out that in the long run, the host and surrounding communities have a lot of leverage in these negotiations, because if they don't get paid, then they don't have an agreement, and there's no proposal. So,
Right.
so it's not a one-sided negotiation.
Right.
But would it, I don't remember the actual language, I haven't looked at this big document, but would it be at all constructive to put in a not be unreasonably withheld, or not be unreasonably, negotiated or something? Would it give any kind of a useful tool to put some kind of language like that in there?
It's a useful tool, Mr. Chairman, only to the extent we're prepared to enforce that. And with an unreasonably upheld criterion, that is often a very difficult thing to determine, whether the withholding is reasonable or unreasonable, particularly when we don't have a plan to look at and really don't know what the yardstick, the measuring yardstick is. And as you say, ultimately, the city or town has a lot of leverage, and ultimately, and in the not-too-distant future, we are going to have regulations that will set out criteria for judging those expenses. Those Phase 2 regulations, it seems to me, that's a piece of the Phase 2 regulations that we really need to front-load and think about doing early on. And we can. It's a severable piece, and we can and should, in the near term, deal with that in a systematic way.
Okay.
So, the second piece is concerns a change. The second piece of the same subject is on page 21, and it concerns an issue that we also will have to deal with. Where the recommendation here is not to make any change at the moment in the draft regulation. But the comment raises an interesting question that we're going to have to deal with and think through. And the comment essentially is this. The comment is that the statute sets the application fee at $400,000, not less than $50,000 of which is to go to cities and towns for the mitigation and negotiation expenses. But that does not, the payment of that money doesn't come off the $400,000 application fee. In other words, if you pay $50,000, so you're only left with $350,000 in your pocket, the applicant is still credited with the $400,000 when it comes time to assessing the costs against it. And therefore, you can't ask for more money if the $400,000, if the cost of investigation are less than $400,000. I just say that to give you a heads up as to an issue that we're going to have to deal with down the road. I'm not prepared to make a recommendation as to how we resolve that issue now, but it's there. Is the issue clear? Have I explained that clearly?
I think so, but isn't effectively the investigation one category of cost versus the mitigation another category?
That may be the way we resolve it. The point, and that may be very well the way we resolve it.
Yep.
The issue being raised, and if one looks at the text of the statute, it's not it's not a frivolous issue. It's an issue that we need to think about. But the issue is that the application fee is $400,000. if you take some of that money and give it to a city or town as part of the mitigation and negotiation fee, the applicant has still got a $400,000 credit against the expenses of investigating his, her, or its suitability. And therefore, you can't ask for more money from the applicant until those costs, the investigation costs, exceed $400,000. It's an interesting issue. We're not going to change the regulations to deal with it now. We'll have to deal with it at some point down the road. So those, there are other corrections and changes that are recommended here, but those are the ones that I thought were worth bringing to your attention. I'll be happy to try to answer any other any questions as to any others that you have.
How about 2417? I'm looking at the document, which is different page numbers, but item 2417, which is way at the end.
Is it line 2417?
Yeah, line 2417.
Page 23.
Page 23.
Okay.
All right. Yeah.
So 24's. How did this? What was the thought process in not having a change? I mean, it sounded to me like it kind of made sense to not have a hearing if there's nothing to talk about.
Well, there is the recommendation. There's no change. I'm sorry. There is going to be a change. The distinction is between an adjudicatory hearing and a non-adjudicatory hearing. An adjudicatory hearing has a technical impact, and that's one as to which there are certain designated parties who have a right to testify and offer evidence and rights of examination and cross-examination and the like. If there's nothing unfavorable about the applicant's suitability, that's not necessary. And so the idea underlying the recommendation is, in those cases, there would be no adjudicatory hearing. On the other hand, the desirability of a hearing, a public process in which the commission comes forward and says the results of the investigation are X, asks the applicant, if the applicant wants to say anything else about its application, have some ceremonial public confirmation of the applicant's suitability and gives a reason why, is, one would think, a useful process to aid the transparency with which we're conducting
So
our business.
so you're accepting the recommendation?
I'm accepting the recommendation.
Okay, I misread.
Yeah, well, it's ambiguous, so I'm not surprised you
Okay.
did.
Okay, 'cause I thought, good.
But you're characterizing in that event where there's no.
That would not be an adjudicatory hearing.
It would not be an
Right, there would be no parties, no examination, no cross-examination. There would be a hearing, a process like this in which
Public
somebody,
process.
essentially like what we just went through. Some people would come, sit at the, representatives of the applicant would sit at a table, we would talk with them, and then announce at the end that we were satisfied, or announce that at the beginning and say we just had a few questions, or however we did it. But it wouldn't have the formality of an adjudicatory hearing.
Section 1405, is that the one was that included in the one you just discussed?
Section, line 1405. No, I didn't talk about that.
Yeah, okay. The recommendation is no change,
Right.
and it kind of looked to me like it was a reasonable suggestion.
The language of that section, which is 108.01, tracks exactly the language of the statute. It is now no broader than the statute.
So our reading is that this point is wrong, that it doesn't? Okay,
Right.
okay. Okay, well, I can't.
And in connection, let me say this, that has to be read in the context of the discussion that I had earlier with political contributions back at page 6. That really is another part of that. And it's been all integrated so that now 108.01 tracks exactly the language
Okay.
of the statute.
Okay. Line 868.
Line 868.
Page 12.
Oops, oh, so we're saying make the okay. I haven't gone through all of your conclusions here, so I didn't realize.
That's at
Your-
page
your
12.
Yeah, it's your page 12, so you're
Right.
accepting that recommendation? Okay. And was the one, 851, the one right before that, I think?
Yes?
That was the one about this vast number of agencies to which some of the
Yes,
bidders might have
that change has
applied.
been, the recommendation is to make that change as well. And to,
Okay, but is this the one that was,
right.
does that simplify it enough by saying to the best of the provider's knowledge that keeps them from?
Yes, the issue there was that the regulation as drafted says that if somebody wants to make an application to keep information confidential, they have to list in their application every other
Right.
governmental entity to which they've provided the same information. The response to that was that some of these entities have provided the same information to 500 or 600 different governing bodies across the world, and it's a hugely onerous burden to require them to say each of the entities to which they've provided the information, and the information may have been provided in slightly different form. So the suggestion was, and everybody, the gaming consultants and the legal consultants recommend that we turn it around and say if they are asking us to keep some information confidential, they have to tell us whether any entity, any place, has refused a similar request with respect to the same information, instead of listing all of the places they've given it. And in fact, that's probably more valuable information than a list of all the places where they've filed it. So this is a better way of policing the validity of their request.
Okay, that, I didn't know, I'm not clear enough of what the words mean by the reasonable or best of their, whatever the word is.
To the best of the provider's knowledge,
How much
that's
of a
right.
burden does that apply?
It implies that they're telling us the truth. I mean, it's
Right.
the affidavits that are accepted in the courts of the Commonwealth have that kind of a qualifier in it. So that's pretty good.
Yeah, okay. 824, I can't remember. 668, did you talk about that one?
Yes.
That-
Well, no, I didn't. But I talked about it generically, Mr. Chairman. This is part of the same
Right.
issue with respect to the ambiguity of the confidentiality regulations. And we've tightened up that entire regulation to make it clear that an applicant has an opportunity, that an individual who is a data subject, let's call him or her, has the right to ask that any information, whether it's simply information that we've defined as confidential or information that the statute defines as confidential,
Okay.
remain confidential. That was ambiguous
Okay.
in the initial draft, and we fixed that.
Okay. I think that's it. Um, 281, what did you do there?
We
Suggestion. Okay,
accepted the
got it.
suggestion.
Okay, good.
Right.
Okay.
That deals with public, definition for publicly traded corporations, and then we changed, we added that definition in a couple of other places.
Right. Just out of curiosity, on ones like 189 and 211, it was just suggestions to clarify the language, and it seemed like we didn't think we needed it.
Well, with respect to those two,
Yeah.
Mr. Chairman, the clarification of the language was really more than a clarification, because it would prohibit the commission. The issue in there was, can the commission appoint as a hearing examiner someone who is not employed by the commission?
Right.
And that's not just a language clarification. To limit it in that fashion would prohibit us from, for example, sending contested matters to the Division of Administrative Law Appeals, which we might want to do and which we have the right to do. So for substantive reasons, we didn't want to do that. There also would be a problem, at least an ambiguity, in our ability to allow some member of a contracting body that was involved in the investigations that we've just talked about to do a hearing, if such a hearing were necessary. We may never want to do that, but it seems to me we want to reserve the right to think about doing that if the occasion arises.
Okay, I don't want to take the time to, and I'm sure that makes sense. I can't read it clearly enough right now, but I'm sure that makes sense, so I won't pursue it. Anything else on Phase 1 regs? Where are we? So do we want to have a motion?
We do, Mr. Chairman, and the motion I would make is this, that the commission accept the recommended changes contained in the document entitled Summary of Public Comments on Draft Phase 1 Regulations, 9/13/12 draft, that is the document that's part of the meeting packet, and the changes contained, and the recommendations in the column labeled Commission Resolution in the document entitled Proposed 205 CMR 101.00-117.00, Suffolk Downs notes regarding form consistency, errata, and typographical errors, and authorize me to incorporate those changes in the current draft of Phase 1 regulations and file the draft incorporating those changes with the Secretary of State on the Commission's behalf.
So moved.
Do I have a second?
Second.
Derek, can you repeat it?
Could we have that read
Let's-
back?
Hopefully we have it in the transcript. Is there any discussion on that motion?
No, except that to note that this is a lot of great work and
Yeah.
a lot of very detailed, necessary work that you have clearly undertaken mostly by yourself. So thank you.
Yeah.
with the aid of our very able consultants and with the consultation of the commission along the way, so.
And just another note, I was impressed by the thoughtfulness, the comments that we received from the general public.
Yes. These were, the regulations were read very carefully, and we got very helpful comments from everybody who commented.
It's made me think about what the process is going to be like when we get to the next set of
Right.
regs.
Did we have the vote, though?
Oh,
Yes, no,
right.
not yet.
No. All right.
Those in favor, yes.
All in favor of that long motion indicate by saying aye.
Aye.
All opposed? The ayes have it.
All right.
Let's have a 10-minute break, and then we're going to get to the investigation, or a couple of other issues. And then come back in 10 minutes.
Good idea. Good work there.